Here are the three things that I'm going to discuss today. First, to give you a little bit of history behind, this sounds very loud. Can you hear me? I don't have to stand on top of the microphone, right? Okay. Give you a little bit of history behind the U.S. Constitution. What came before the U.S. Constitution? Because what came before explains quite a bit about why the Constitution is the way it is in some respects. Then I want to walk you through some of the most important principles of the Constitution. Grazie. And then I want to focus on federalism, because federalism is a concept, at least as we understand it in the United States, that's quite strange to Italians, quite strange even to Germans, quite strange to almost everybody outside of the United States. And it's an issue that's of very, very great political importance today. And so we'll focus a little bit on federalism. First, to give you a little bit of historical background, and let me say that everything we're going to discuss today is a little bit superficial. That's because I'm trying to cover the substance of what would normally be a course that would be a year-long course that meets for 4 hours a day. And so I'm just going to give you the flavor of these issues. So the history of how the U.S. Constitution came to be will be basically condensed into one slide and about 2 minutes of discussion. Obviously, there's a lot more to it. Colonists who came from Europe to what became the United States of America, came largely out of protest of certain lack of freedoms that they perceived in Europe. Lack of freedom of speech, lack of freedom of the press, lack of freedom to practice their religion as they wished. And as they settled in what became the United States, they had a long list of grievances against King George III, who ruled the colonies. And the long list of grievances included, again, lack of freedom of speech, lack of freedom of the press, imposition of restrictions on religious practices, unfairness or a lack of transparency in criminal and civil procedures. And we're going to look at a little bit more directly at some of these grievances later. The American Revolution was fought as a response against this colonial rule, which was seen as very centralized in the king, very distant, and very, very powerful. Although England at that time, as it does today, of course, had a system of separation of powers. It was not a real separation of powers because the monarch was all-powerful and basically governed not only the executive powers, but also controlled the legislative and judicial powers. And so this was the immediate cause for the American Revolution. After the American Revolution, so we fought, we won, okay, it's over, and the colonists said, what do we do now? They set up a form of government that bonded the colonies under a document called the Articles of Confederation. The Articles of Confederation was a very weak form, or created a very weak form of national government. There was no real authority in the national government, no power to tax and spend, no power to bind the states. It was essentially what I've seen described as a league of friendship. And what it did, the most important function of the Articles of Confederation, was that it was a pact between the states to respect the sovereignty and autonomy of each of the other states. And so the big and powerful New York agreed that it would not take over New Jersey or Vermont. The big and powerful Massachusetts said, okay, we'll respect the sovereignty of New Hampshire. We won't conquer them in a minute, which they could have done. So it was this league of friendship. But it became apparent very quickly that there were many problems with this government under the Articles of Confederation. The national government could not, for example, raise and maintain an army or a navy. So there were tremendous concerns about the protection, not of the colonies against each other, but from other internal forces, the Native Americans, for example, what we used to call the Indians, and external forces, because France, among other countries, had their eye on this new piece of land. And so that was one problem. There was no ability to protect the nation militarily. The second problem actually had to do with commerce. What happened was individual states, which were really acting as little countries, were enacting legislation, commercial legislation, that was protectionist. New York would enact legislation that protected New York commerce and New York consumers. And every other state would do the same. And it became impossible to really create a national economy. And so these two concerns, among others, led to the calling of a meeting to amend the Articles of Confederation. And what became a meeting to amend the Articles of Confederation quickly turned into a meeting to eliminate the Articles of Confederation and write a new document which ultimately became the Constitution. And so the historical realities that the framers, we call them our founding fathers, and they were in fact just men, of course, and they were white men. They were all very similar white men. They were all aristocratic white men. But really the leaders, the political and economic leaders of the day, representatives of each of the states, came to Philadelphia and in secret went about writing this Constitution. But they were very mindful of the political realities. One was, we had just fought this American Revolution, a very bloody and expensive war, against a distant, centralized national government that was perceived as too powerful and abusive. So they said, well, we better be careful not to create a government that seems too distant, too central, too national, too distant, too abusive, because the people won't like that. We just fought this war to get away from such a government. Okay, we can't have anything that really feels too similar. And the second problem was that they were asking the states, who at this point had all the power, they were asking the states to give up some of that power and vest it in, well, something that seemed like a distant national centralized government with a lot of power. So they were very, very mindful of these political realities. Ultimately, what came out was the Constitution of 1787, ratified in 1787. It has three main parts. It had, in its original form, it had two parts. It had a preamble, which set out some of the basic themes and goals of the Constitution. The preamble is the thing that starts, "We the people." You've all heard of that. Everybody seems to have heard of "We the people." Nobody really knows what follows "We the people," but it's not a terribly important textual source. It's important because it sets out some of the aspirations of this document that was being created and the country that was being formed under this document. And then it has 7 articles. So the body of the Constitution, as it was ratified in 1787, had only 7 articles, 7 provisions. It's very concise. And the articles do 4 things. They set up a national government and provide for a system of separation of powers and checks and balances among the 3 branches of government. We'll speak a little bit more about that. It also defines the relationship between the national government on the one hand and the states on the other hand. Now, when you Italians, when most people speak about states, you think of Italy as being a state, Germany as a state, France as a state. In the United States, we use the word state as a very particular thing. Nation, country, federal government, that's what you think of as states. When we speak of the United States as a whole, we do not use the word state, we use the word nation, country, national government, federal government. When we use the word state, we're referring to New Jersey. New York, Connecticut, Pennsylvania, California, Texas. So when we use the word state, we're always referring to these political subunits, never the country, okay? And that's important because I think it represents a very big difference in the way we think about that term. So the Articles also provided for a process for amending the Constitution and a process for ratifying the Constitution. And that's it. What are the amendments? The amendments are changes to the Constitution that came later. And we're going to look at those as well later. Everything in this Constitution, virtually everything, represents the new Americans' experience under colonial rule. And in particular, this fear of centralized power, this fear of too much accumulation of power in a distant, national, centralized government that was far from the people, and a concern over the protection of individual rights. And we're going to see that as we go on. I'm going to skip some of the slides simply because I'm not sure how much time we'll have, but I'm going to make these slides available somehow, so you'll all have them if you want them. So the Articles do two main things. Yes, they also set up a process for amending and for ratifying the Constitution, but the obsession of the Articles, the main concern, was to set up a national government. And the national or federal government was set up using a system of separation of powers and checks and balances. Now, we don't think we came up with this idea, obviously. Europe came up with this idea many, many years before. But the reason we mention it, the reason that we make such a big deal about it, is that the separation of powers, a real separation of powers and a real system of checks and balances was extremely important to the framers of our Constitution, that it be genuine. Why? Again, because of concerns over their experience with totalitarian rule under the British monarch. So it was very important that they create a system of real separation of powers and real checks and balances. And the second primary obsession with the Articles was to define the relationship between this national government on the one hand, the United States, and the individual states on the other hand. And we refer to this power-sharing arrangement as federalism, the sharing of power between the national government and the state powers. And because of the history, the very recent history of the framers, the notion was, okay, how do we split this up? We certainly have to create a strong national government to avoid the problems and the limitations of the Articles of Confederation, but we must make the states and the people feel that the states are still retaining important powers. We're going to see a little bit more about that as well. Let's take a look at the separation of powers. Everybody knows what this means, I think. 3 branches of government, each with its own role, each with its own powers. So Article 1 established the legislative branch, and the legislative branch makes the law. Article 2 establishes the executive branch, and the executive branch, of course, administers or enforces or executes the law. And the judicial branch is established by Article 3 of the Constitution and interprets the law and applies it in particular cases brought by parties and interests. And in the very famous words of the judicial opinion Marbury versus Madison, perhaps you've heard of it, the Supreme Court or the judicial branch generally gets to say what the law is. And under the very closely related doctrine of checks and balances, each branch has some control, some power to intervene in what the other branches do, again, so as to prevent an abuse of power. And just to give you some examples that are very important, the president has a veto power over laws passed by Congress. So Congress can pass a bill, and the president says, no, I will not sign this bill into law. Congress, at the same time, can override a presidential veto through a supermajority vote. And that's a very important check that Congress has over the executive branch. The President and the Congress have an important check over the judicial branch, which is to say that the President nominates federal court judges. It's a very, very political process. And the Senate has to confirm those nominations. So all federal court judges have gone through a check by both the President and the Senate. Congress controls the budget. We call that the power of the purse. And this is an extremely important check that Congress has over each of the other branches. Congress decides how all of the money is spent. And of course, everybody wants money, so that's a very important check that Congress has. Congress also has the power to impeach and remove from office federal judges and executive officers. Again, a very important congressional check. I haven't mentioned yet any important check that the courts have over the other branches, over the political branches. Well, the courts, it turns out, have what we call the power of judicial review over both the executive and the legislative branches. This is the power to decide that something that the legislative branch has done or something that the executive branch has done is unconstitutional or otherwise illegal. So this is an enormous, enormous power that the judges have to say, no, Mr. President, you can't do that, or no, Congress, you have passed a law that actually exceeds your authority under the Constitution and therefore is illegal, is unconstitutional, is without effect. I want to say just a few things about each of the three branches so you can understand a little bit what they look like, how they're structured, now that you know what they do. Article 1 of the Constitution, of course, establishes the federal legislative branch. It says that, it begins by saying, all legislative powers herein granted, all legislative powers herein granted, meaning all federal legislative powers reside in the Congress. This is known, or this has evolved into what is known as the Non Delegation Doctrine. And what it means, what the Supreme Court tells us it means, is that Congress may not delegate any of its lawmaking authority to anybody else. The reality is, though, that Congress delegates its lawmaking authority all the time. What I understand, I don't know anything about Italian administrative law, but what I've heard from people who do is that the main difference between U.S. administrative law and Italian administrative law and administrative law in many other countries is that in the United States, Congress delegates a good deal of rulemaking to Congress, to the executive branch, to the administrative agencies. And in fact, it is not uncommon for Congress in legislation to say, we create XYZ agency and we delegate to the agency the power to make rules and regulations about food and drug safety that are in the public interest. And that the delegation can be as broad as in the public interest or in the public convenience and necessity or things that serve the public interest. And the Supreme Court has upheld these delegations as being consistent with this non-delegation doctrine. So what you find is that very often Congress legislates very, very broadly and leaves an enormous amount of power in the executive branch to fill in the blanks of that legislation. Congress, as it is in many other countries, is composed of two chambers, the House of Representatives and the Senate. The House of Representatives has 435 members, and they're proportioned according to population in each state, and each representative is voted into office by the people in a particular congressional district. They serve very short 2-year terms. The Senate, however, only has 100 members. It's generally considered the more elite body, 100 members, 2 from each state, and they serve 6-year terms. But both chambers are involved in the identical way in the lawmaking process. Both chambers must agree, must have a majority vote in favor of legislation for that legislation to be sent to the president for his signature. The federal executive branch is established in Article 2 of the Constitution. Article 2 speaks very little about the structure of the executive branch. It speaks about a president, who's of course the chief executive officer. It speaks about a vice president, but it does not speak about the other members of the executive branch, such as the White House staff, such as the cabinet, which are secretaries of the various departments, such as the independent agencies, which is a vast network of bipartisan agencies and commissions who do much of the work that's involved in running the government on a daily basis. The president has some very, very important powers, as you can imagine. He has important diplomatic and war powers. He represents the country in all of its international affairs. He is the commander-in-chief of the armed and naval forces, and he is charged with responsibility for taking care that the laws, the federal laws, are faithfully executed. That's known as the Take Care Clause. In addition, the president nominates all federal judges, all cabinet members, ambassadors, and other high-level ministers and consuls. So the president in the United States, unlike in Italy and other parliamentary systems, the president is a very, very powerful figure. Article 3 of the Constitution sets up the federal judicial branch. The organization in the Constitution is very simple. The Constitution says there shall be one Supreme Court, and Congress is given the power to establish inferior or lower level courts. So we do not have, like you do, we do not have a constitutional court, which is very common in Western European countries and elsewhere. We cannot, as a constitutional matter, the Supreme Court is the highest federal judicial authority. Congress has created a fairly impressive network of lower-level courts that are based both on hierarchy, with the Supreme Court at the top, and on geography, with district courts and circuit courts separated throughout the country. The selection of federal judges, I've mentioned earlier, it's a very, very political process, obviously, but judicial independence is guaranteed in the Constitution by a system which gives life tenure to all federal court judges. They serve, in the words of the Constitution, during good behavior, which has always been interpreted to mean that unless a federal judge is impeached for treason, bribery, or other high crimes and misdemeanors, and convicted of such a charge, unless that happens, and it rarely happens, that person can stay on as a federal judge for his entire life. I know a judge, he's a friend, sort of. He's about 96 years old. He's a Court of Appeals judge, and he is not retiring. We had a member of the Supreme Court of the United States who retired just about 1 year ago, and he was 90 or 91, possibly 92 years old. So it's life tenure, and we mean it. And this has really guaranteed a sense of very, very strong judicial independence. In addition, judicial salaries cannot be reduced, so the political branches can say, well, we want Judge Fine. I'm not a judge, but in my fantasy, I'm a federal judge, and the president or the legislative branch cannot say, well, we know we can't fire Judge Fine, but we'll reduce her salary to $1 a year. Obviously, that's about the same as firing me, cannot be done. So federal judges do have enormous amount of independence from the political branches, but the jurisdiction of the federal courts is limited. And this is all part of federalism, all part of respecting the sovereignty and autonomy of the states, because we have, in addition to this system of federal courts, we of course also have a system of state courts. And so the subject matter jurisdiction of the federal courts is limited to certain kinds of cases, and federal courts can only hear, in the words of the Constitution, Article 3, cases and controversies. And this term, cases and controversies, has been interpreted to impose certain what we call justiciability requirements on federal courts. Things like standing. You must be an appropriate plaintiff with a genuine interest in the outcome of the case in order to bring a case in federal court. The case cannot have become moot. The case must be a case that is ripe, that is ready, that is matured enough for federal court review. And I guess the way of describing all of these requirements fairly swiftly is that federal courts do not give advisory opinions. They only give opinions in real, live cases with a real party in interest. Is it okay if I ask if there are any questions right now before we move on? We keep going.
Yes.
No questions. Okay, we go on. But if you have questions, hold them, and maybe if we have time. Okay. Allora, okay. What do the amendments do? What do the amendments do? The amendments do two things. The most important of the amendments provide for individual rights and liberties. We have other amendments that I am not going to talk about today because we generally consider them less important. Not that they're without importance, but since we only have limited time, they're a little bit less important. And so the other amendments are basically refinements to the articles. Things they should have done in the articles or wish they had done, or as time went on, it became important to do that. For example, in Article 1, the original version of the Constitution, senators, members of the Senate, were elected by state legislatures. We didn't like that. That didn't seem right after a while, so that was changed in an amendment, and instead, people voted directly for their state senators. There was no limitation to the number of terms a president could serve in the original version of the Constitution. Ultimately, in the 1940s, after President Roosevelt, Franklin Delano Roosevelt, was elected 4 times, I said, maybe we should have an amendment about this. We don't really like the idea of a president who serves forever. And so they imposed a restriction that's written a little bit oddly, and we're not quite sure what it means, but it seems to suggest that what it says is you can only be elected twice as president. So these are other kinds of amendments, but the most important of the amendments are the individual rights and liberties. If you read the body of the Constitution, sometimes you're surprised. I was surprised the first time I read the Constitution that in the body you find no reference to personal rights and liberties at all. None. There was an agreement during the Constitutional Convention to disagree about the inclusion of a Bill of Rights. Some states said, we must have a Bill of Rights. We're creating this horrible, national, distant, centralized government. We must have protections for individuals against intrusion by this big, ugly national government. Others said that's ridiculous. Not necessary. The national government is a government of limited powers. If we don't say, which we don't, that the national government can intrude upon your right to free speech, then clearly the national government cannot interfere with your right to free speech. They ultimately did not resolve the conflict, and they said, look, let's get the government up and running. This is super important. We really need to get the government up and running. Let's create the government. we can discuss the issue of a Bill of Rights after the Constitution, the body of the Constitution, is ratified. Let's table this. Let's deal with it later. So that's essentially what they did. But immediately after the Constitution was ratified, there were a few states that refused to ratify without a Bill of Rights. And so immediately after the Constitution was ratified, they got right away down to the business of drafting a Bill of Rights. When you hear the term Bill of Rights, it refers to the first 10 amendments to the Constitution collectively. And they were ratified 2 or 3 years after the body of the Constitution. So it was done very, very quickly. So the main sources of the Bill of Rights are, the main source of individual rights and liberties are the Bill of Rights, the first 10 amendments, and in particular Amendments 1 through 8, and then what we call the Reconstruction Amendments, the 13th, 14th, and 15th Amendments. These are the major sources of individual rights and liberties in the U.S. Constitution. Let's take a very quick look at the Bill of Rights. Again, this is something that we would speak about in more detail if we had time. The Bill of Rights provides for the following protections: the right to be free from intrusions or interference, and the right to speech, press, and association. The right to association is basically to hang out with whoever you want to hang out with, okay? And, an interesting case from not too long ago on the right of association involved the Boy Scouts Club of the United States. Do you have the Boy Scouts and the Girl Scouts? Okay. So the Boy Scouts, I guess you're all a little bit familiar with it. The Boy Scouts tried to throw out a scout leader whose name was Dale. The case was called the Boy Scouts of America versus Dale. And Dale was gay, and he was very active in the gay rights movement. And the Boy Scouts didn't know he was gay. He had been an Eagle Scout, which is like, that's like the best thing that can happen to you. If you're a Boy Scout, you become an Eagle Scout. And then he came back as an adult to be a troop leader, and somebody from the Boy Scouts administration was reading the newspaper and found that Dale had been interviewed at some gay rights protest, and they kicked him out. And Dale said, no, I have a statutory right to accommodation to be part of the Boy Scouts. And the case went all the way up to the Supreme Court, and the Supreme Court said, no, actually the Boy Scouts' First Amendment right to free association makes this state statute unconstitutional. The Boy Scouts have a right, consistent with their mission, to exclude openly gay individuals from membership. So that was an interesting case on free association. Free speech and the right to free press and the right to free association are very, very powerful rights in the United States. You could say things against the president. You can have a lot of fun with free speech. The right to the religious freedoms in the Constitution are twofold. On the one hand, there's what we call the No Establishment Clause, the no establishment of religion. It's not entirely clear what this means. On one end of the spectrum, people say, all it means is there cannot be an official government religion. There cannot be an official religion of the country. We can't make Christianity the official religion. On the opposite end of the spectrum, people say, no, there must be a strict division between government and state. What's the reality? It's somewhere in between. It's very hard to say where. If you've ever been to the United States, maybe you've seen a dollar bill. Did you ever see a dollar bill? Did you ever notice something on the dollar bill? In God we trust is on every dollar bill and every $100 bill and everything else. In God we trust. If you go to a court, you might be asked to swear on the Bible that you will tell the truth. There is not a strict separation. By the way, you can refuse and ask instead to give a simple affirmation that you affirm that you're telling the truth, you understand the importance, etc. But there is no doubt that there is religion and civic society in the United States. So, but I think it's neither extreme, it's somewhere in the middle, and it's a little hard to tell you where exactly it falls. Free exercise of religion. Everyone can exercise their religion freely. But there are some fantastic cases, for example, prisoners who get together and they create a religion. And the religion, by the way, it does not have to be one of the 7 great religions, the well-recognized religions in the world. I made up that number. I don't know how many there are, but probably more than that. But it doesn't have to be a very established, well-recognized religion. You can join together with your friends and create a religion. And if those religious beliefs are deeply and genuinely held, then you can claim free exercise of religion. But we have these very interesting cases where some very imaginative prisoners got together and they created a religion, and the religion required them to use all sorts of drugs and have prostitutes at their disposal. And it went up to the Supreme Court, and the Supreme Court said, well, no, actually, this is not a religion. This is just your attempt to get drugs and women into jail. No, it's not going to happen. The right to keep and bear arms is a right that we've learned about recently in the last 3 or 4 years, even less perhaps. The Supreme Court has decided that the right to bear arms in the Second Amendment is an individual right. That's why we have this fairly free, but not entirely free, possession of handguns in the United States. We have a provision in the Bill of Rights on eminent domain, that the government can take private property, but it must do so only for public use, and it must provide the landowner with just compensation. The Bill of Rights, and I want to talk about this particular provision, which is the Fifth Amendment. I want to talk about this a little bit more later, but has a provision for the government may not deprive you of life, liberty, or property without due process of law. This due process clause is enormously important and has both a procedural component and a substantive component that we'll look at later. An interesting one for most lawyers and students from almost everywhere else in the world is that you have the right to a trial by jury in most civil cases in which you're seeking money damages. So if you're suing someone for $50, you usually have the right to a jury trial. We have a number of protections for criminal defendants in the Bill of Rights. The freedom to be free from unreasonable searches and seizures, both of your person, of your home, of your things, of your effects. A prohibition on double jeopardy, meaning you cannot be tried twice for the same crime. No forced self-incrimination. You cannot be forced to testify in a way that would incriminate you in some sort of criminal enterprise or activity. You have the right to an attorney. You also, that's what the Constitution said. What the Supreme Court says is you also have a right for the government to provide you with that attorney free of charge if you cannot afford an attorney, but you probably all know that from television. You have the right to be free from punishment that is excessive or cruel and unusual. This is the issue that comes up most often regarding this provision is the death penalty. We still have a number of states in the United States that still have the death penalty. Those states that have the death penalty, though, are restricted by this amendment, the Eighth Amendment, so they cannot impose the death penalty in a way that would be cruel and unusual or excessive. More special protections in criminal trials. You have the right to a speedy and public criminal trial. By the way, if you go through this Bill of Rights and you look at this list of protections, you can tie them directly to grievances that the colonists and early Americans had against British rule. Exactly. They match exactly. So these were the things that irritated the colonists under British rule, and so these were the things that were most important that be protected as they created this Bill of Rights. The right to a trial by jury, the right to be informed of the charges against you, the right to confront witnesses, to cross-examine witnesses, and the right to compulsory process for witnesses in the defendant's favor. So if, let's say I'm a criminal defendant and Professor Del Vecchio knows what happened. She was a witness, and she knows I did not do it. But she says, I don't want to get involved, which is a very natural response. The government will compel her presence and require her to testify. She might say she doesn't remember, but that's a different story. But the government will guarantee the presence of an individual who has relevant facts in my favor. So that's primarily the protections that we see in the Bill of Rights. Again, I'm going to return to due process later. The Reconstruction Amendments are the 13th, 14th, and 15th. These are the most important of the post-Bill of Rights amendments. First, why do we call them the Reconstruction Amendments? We call them the Reconstruction Amendments because they were enacted in the years following the American Civil War. That's the period, the historical period just following the Civil War was called Reconstruction, the period of reconstructing, putting the country back together again. The first order of business was to abolish slavery. That's what the Civil War ostensibly was about, and so the first order of business immediately after the Civil War was to abolish slavery. Let me skip the 14th Amendment for a moment and tell you about the 15th Amendment. The 15th Amendment said, okay, now slaves are free, blacks are free individuals. The 15th Amendment gives those people, former slaves and all black people, all black men, the right to vote. Okay, the right of women to vote did not come until much later. So black men got the right to vote in 1865. Women got the right to vote, all women, adult women, got the right to vote, I believe, in 1920. So at this point, only men were able to vote. So of course, when the vote was extended to black people, it was only to black men. The 14th Amendment provides for due process and equal protection. Now you may say, why do you need due process? You already have due process in the Fifth Amendment. And in fact, if you look at the due process clause in the Fifth Amendment, and you look at the due process clause in the 14th Amendment, you see that the language is exactly the same. Exactly the same. And it says, the government shall not deprive any person of life, liberty, or property without due process of law. Exactly the same, with one very, very big difference. And the big difference is this. The Fifth Amendment, as well as all of these Bill of Rights protections, all of them, originally applied to protect individuals only from federal government action. The Bill of Rights protections originally applied to protect individuals only against intrusion by the federal government. Why? Because historically, at the time the Bill of Rights was ratified, nobody was worried about state intrusions on individual rights and liberties. The states were your friends. The states were very close to you. And individual states each had their own bills of rights. They may have varied a bit, but they were pretty much the same as this Bill of Rights. And so the Bill of Rights begins with the words, Congress shall make no law, followed by this list of things that the federal government could not do. The 14th Amendment, though, was geared towards the states. Why? Because just like the problem with the ratification of the Constitution had to do with the federal government, the national government, the whole problem with the Civil War was about the states. It was about the southern states seceding, ripping apart from the Union. And so the remedy had to be based on limitations on state action. So the 14th Amendment specifically says, nor shall any state deprive any person of life, liberty, or property without due process of law, nor shall any state. Then the 14th Amendment has something else. It says, nor shall any state deprive any person of the equal protection of the laws. Let's start with due process. Let's start by saying this. The 14th Amendment dramatically changed the relationship of the states to the national government. I want to talk about 3 special issues. I forgot that I had a slide on it. Okay, so fast. 5 minutes?
5 minutes.
Okay, 5 minutes. 5 minutes, okay. The incorporation...
Because it's important of the question.
Absolutely. The incorporation of the Bill of Rights protections. As we said, the Bill of Rights protections initially applied only as against the federal government and not the states. What the 14th Amendment did was extend, on its face, due process to the states. What this allowed the Supreme Court to do was, in a series of individual decisions, extend particular Bill of Rights provisions to the states and give individuals a vehicle by which they could challenge state action, the action of New York or New Jersey or Connecticut, as being violative of the First Amendment free speech doctrine, the First Amendment prohibition on restrictions on the exercise of my religion. It extended the right to be free from cruel and unusual punishment to the states. Basically, over a number of years, including one decision from 2 years ago, the Supreme Court has found that virtually every protection in the Bill of Rights is equally applicable to the states. So the 14th Amendment was used as a vehicle. The due process provision in the 14th Amendment was a vehicle to allow individuals to claim a violation of Bill of Rights protections against the individual states. What about equal protection? Equal protection, okay. Well, you look at the 14th Amendment and it says, no state shall deprive any person of equal protection. So we had a very famous case, you might have heard of it, called Brown versus Board of Education. Brown versus Board of Education says that the Board of Education of Topeka, Kansas could not separate or segregate school children on the basis of race. What used to happen was that little black school children were sent to one school, little white school children were sent to a different school, and up until Brown versus Board of Education, the Supreme Court said, that's okay, as long as the schools are roughly equivalent in terms of services and professors or teachers and books and money spent per pupil, it was okay. Suddenly the Supreme Court said, no, the mere act of segregating them on the basis of race is a violation of equal protection. The next case that comes up comes to the Supreme Court from the District of Columbia. The District of Columbia is not a state, it's a federal district, governed by Congress, ruled by Congress. Same exact facts. Little school children were being segregated, the white kids sent to one school, the black kids sent to another. And the black school kids' parents said, this is the same as Brown versus Board of Education. And the government said, no, it's not. Because where in the Constitution do you find an equal protection clause applicable to the federal government? And you don't. There's nothing in the Bill of Rights about equal protection. Remember, we're a country founded on slavery. There was no sense of equal protection in the 18th century. So what the court said was, well, just like we incorporated the Bill of Rights protections into the 14th Amendment to make them applicable to the states, we impose a reverse incorporation of the equal protection doctrine applicable to the states by the 14th Amendment. We find that that is part of what due process means in the Fifth Amendment. And we think that due process in the Fifth Amendment is broad enough to include these concepts of equal protection. And so school segregation on the basis of race, even by the federal government, is unconstitutional.
Allora, ragazzi, qualche domanda su questa presentazione? Pronti? Forse provare con questo. Provare con questo.
So, according to what you say, at the backgrounds, you say when in the 1787 they decide what were the main four principles the Constitution had to be based on. So, what they were focused on, you explain us the reason why they decided to be focused on these four, and why they introduced the check and balance system.
Yes.
And the fear for the central government. So, right now, after everything you say, would you suggest something? What do you think it didn't work in what they wanted? And what would you change if you can change something? The most important thing.
Wow. We never should have allowed questions. That's a great question. I don't think anyone's asked me that before. And as a result, I've never thought about it before. You know, one of the things, all right, I'm going to give you a non-answer, and maybe as I give you the non-answer, I'll think of a better answer. I think one of the things that, when they developed the Constitution, and for those of you who are interested in the constitutional history, there's a fantastic set of essays that you can get. You could probably download them for free on the internet, but you could also buy them in book form, and they're called the Federalist Papers. And it's the closest thing we have to sort of legislative history of the Constitution. They were drafted as propaganda. They were newspaper articles that were propaganda to get people to sign on to the Constitution, to agree to ratify the Constitution. And they explain each and every provision of the Constitution. Why did we decide to do this versus doing it different ways that were discussed? Why did we do a 4-year presidency rather than a 6-year or a 2-year? Why did we do a 2-chamber Congress? Why did we do this and the other thing? It's fascinating. And one of the things that you find in the Federalist Papers is language about the judiciary system. There was concern about judges having this life tenure, concern about judges not being chosen through any political, well, not being, their lack of accountability. So they had lots of independence, but not accountability. And one of the things that the framers said in these Federalist Papers and elsewhere is, you don't need to worry about the judicial branch. The judicial branch is, and it's become a very famous phrase, the courts represent the least dangerous branch. You don't need to worry about the courts. They have very little power. They cannot grab cases. Cases must be brought to them by parties. They have limited jurisdiction. They really can't do that much. You don't need to worry about them. I think if there was a weakness in the text of the Constitution, it may have been not making more clear what the judicial powers would be. Having said that, though, that was resolved very, very quickly. Did any of you ever hear of Chief Justice John Marshall? He was one of our first Chief Justices, maybe the second Chief Justice. He had a very long tenure. And what he did during his tenure, he's the author of Marbury versus Madison, which is a case that, I don't know if you've ever heard of it, but most people in the United States, if you said, what is the single most important decision ever by the Supreme Court of the United States, most law professors, at least, I'm not sure what that means, but would say, it's Marbury versus Madison. It establishes power of judicial review. And this was the one of a number of Supreme Court decisions from the John Marshall era that really solidified the power of the federal courts, and that gives us today a system in which the courts provide a very active and very important check on what the political branches do. And we saw that especially during the Bush era, where Bush was just doing all these crazy things and Congress was letting him, and it was only the courts that were able to come in and say, actually, no, Mr. President, you can't do that, even with congressional approval, because Congress, that's an unconstitutional law. And so if there's one weakness in the text, I think it's that it doesn't properly elucidate what the role of the court is, but it hasn't been a problem because the courts have taken on such a defining role for themselves. So you should stay in touch with me by email. And maybe someday, look at all this stuff I did. Okay, next year. Maybe next year I could come back and do the rest, but maybe I'll think on my very long plane ride home about a better answer to your question. Because our system is by no means perfect. I don't want to act like, oh, it's so great. It does work reasonably well. Here's my email. It works reasonably well. What our biggest problem is, and maybe you all understand this, our problems are political. Our problems are not necessarily that the system is so horrible. And I think maybe you all can empathize with that at the moment. The problems we have are political. I don't know how to come up with a governmental system, a structure, that could fix that. And if I could just say one more thing about what the big debate is today, because this may be another sort of problem. The big debate today is how much power does the national government really have? And the general divide is that conservatives, Republicans, believe that the national government should be very limited, very small, not have a lot of power. Democrats, progressives, what we call liberals, believe, no, the national government needs lots of power to do good things. And I know that Dr. Gallo knows more about this than I do, but there's a very big debate now over health care reform. And the Supreme Court has agreed to review the question of the constitutionality of the health reform legislation that President Obama had Congress pass a few years ago. And the question presented there is all about, the primary question is all about the limits of the national government. And it's really a question of federalism and where is this dividing line. And so that's maybe something that the Constitution could have been clearer about. But on the other hand, so I'm still not answering your question, but on the other hand, the beauty of our Constitution is that it was drafted so broadly, so imperfectly, so imprecisely, because it has allowed the Constitution to evolve as we as a society have evolved. So we have this very old Constitution with very few amendments, and we're able to have that simply because the framers did not specify every little thing. If they had specified lots of little things, we would have had to go back and amend that Constitution many, many times over the last 200 years. But instead, they left it to this judicial power in the end to sort of specify, well, what does due process mean? What does equal protection mean? What does commerce among the several states mean? So some precision, some additional precision might have been a good idea. On the other hand, it would have thwarted the judicial development of the Constitution in a way that's worked reasonably well. So that's a great question. Terrible answer, but...
Qualche altra domanda? Perché poi la professoressa deve partire, ha problemi di aereo. Qualche altra domanda?
And if you want to ask in Italian, maybe somebody could translate if you're uncomfortable.
No, dai. Roberto Virgio, sì. Vieni se, perché non si sente.
Let me thank you for your interesting and deeply helpful presentation. Some students are attending a law of international organization course this semester, may I ask you something concerning the Avena case decided by the International Court of Justice? Because in that decision, the International Court of Justice suggested to apply the Miranda rule, that's called the Miranda rule, also for foreign people and to have an extension of this rule concerning consular assistance. In your opinion, would this suggestion be consistent with the Fourth Amendment, I believe? Thank you.
Wait, sorry, tell me a little bit more about the Avena decision.
Yeah, the Avena case was a case concerning some Mexican people. They were, there was a privation of their freedom, and Mexico said that they need assistance, protect consular
assistance.
Yeah, and the International Court of Justice said, maybe United States of America could have a new formula for the Miranda rule. Thank you.
So, thank you. Another question I'm going to give a terrible answer to because, so I know a little bit about this issue, but only a little bit. I had forgotten the name of the case, but so there's this long history in the United States. It's a long, unfortunate history. We're a member, we're a signatory to the Vienna Convention on Consular Affairs, as Italy is, as many other countries are. And one very important provision there that I always remember when I travel is that if you get arrested in another country that's a signatory, they're supposed, if you're a foreign national, you're supposed to be, by international law, informed of your right to speak to a consular official. So if I got arrested here in Italy, I happen to know many lawyers, but apart from that, Italy would be required to present me to some U.S. consular official here in Italy, and that person would be able to help me through the process and provide whatever assistance he or she could provide. In the United States, for many, many years, we ignored that, and we did not give consular assistance to foreign nationals. And it was denied, and in a number of cases, I'm not sure if in the Avena case this happened, but in a number of cases, the defendants were were sentenced to death, execution. And that's obviously a pretty big penalty, and not something that should happen without the full exercise of constitutional rights, including our obligations under international law. So that's where my knowledge sort of stops, except that there have been cases in the international courts that have suggested that I didn't realize that it was supposed to be included in the Miranda rights, that if you are a foreign national, you have the constitutional right, the legal right to be presented to your consular official for consultation and guidance. What I do remember is that after some decision by the International Court, President Bush, of all things, asked the state of Texas to retry somebody who was in the similar position, and it may have been, it wasn't Avena, it was another Mexican, but with a Colombian name. The Colombian name was something, but it was a Mexican, and it was the same story where this Mexican was on death row, and Texas refused. I mean, this is kind of incredible that Bush was actually in favor of a retrial, giving this man his consular official rights, recognizing the importance of the International Court's judgment, and Texas said no, and the case went up to the Supreme Court in a case that starts with an M. It's a Colombian name, Mendoza? Maybe, some name that starts with an M. And the Supreme Court said that the state of Texas is not required as a matter of constitutional law to supply this. And that because of federalism, the judgment of the International Court was not binding on Texas. This is what I remember from that decision. This was a big low point for the Supreme Court. This is a big low point for the Supreme Court. I feel very embarrassed to come and have to talk about this, but it's important that we talk about it. It's a big low point for the Supreme Court. It's a big low point for the country. But what has happened, I understand, is that now, today, most states do give you that right. It's just the easiest way to implement international law. And the policy now is that states are encouraged and required by international law to give this warning as part of the Miranda warnings. So you all know what the Miranda warnings are. You've heard them on TV. You have the right to remain silent. If you speak, anything you say can be used against you. You have the right to an attorney. If you cannot afford one, the government will provide one for you. And now apparently it is common practice in most or all states to also say, if you are a foreign national, you have the right to meet with with your consular representative. But apparently it's not constitutionally required. Boo to the Supreme Court, but I hope that was more or less responsive. Yeah. Sorry.
Ok.
Va bene. Ah, grazie. Thank you.